You know, as human beings, there's lots of things we tend to put off and procrastinate about. And for many of you, one of them is your estate planning. Well, if that sounds like you, stay tuned to this week's episode of the Retirement Income Source, where it's all about the income. And welcome to the Retirement Income Source, where it's all about the income. I'm David Scranton, here with Sarah Samuels. And today we're talking about estate planning. One of the most disdained topics, one of the things that people tend to procrastinate the most. And maybe it's because you don't want to think about your mortality. But today, we're going to explore this also important topic and what you can do to make the decisions easier and why having an estate plan is so essential for virtually everyone. So Sarah, let me ask you, you guys are young. You have wills?
I do have some certain documents, Dave. And first of all, it's great to be here with you and, of course, with all of our listeners. And we appreciate everyone listening to the Retirement Income Source and spending time with us. Now, while I don't have a full estate plan yet, I do have some documents like, transfer on death agreements, those kinds of things. But I do think it's never too late, to start estate planning. That's the other thing. A lot of people have this idea that estate planning only happens, even in death, right? Like it's only something that occurs when you die or is carried out. And that's another big misconception when it comes to estate planning.
Do you know what the definition of estate planning is?
Let's hear it.
The accumulation, protection, and distribution of assets. So when you think about death and dying, the distribution, the wills and all that, you're really thinking about one of those aspects. But estate planning is really much, much bigger than that. And, people oftentimes get stuck. And I think we'll talk about this a lot in the show, but they get stuck because they're trying to figure out, well, who should the executor be? Who should the trustee be? Who should be the guardian, right? So you and I are married. I know, scary thought for you, right? So you and I are married, we have kids, and we can't decide, I want my sister to be the guardian, you want your brother to be the guardian. So we can't agree, it's contentious, so what do? We do nothing. Right? Or executor, same thing, okay? I want a relative of mine, you want a relative of yours. We can't agree, we do nothing. And that's not the right answer. So remember, you can always change documents at any time in the estate plan, but the key is to get something done. And today, our goal is to help you through some of those hard decisions so that you can take the steps that you've known for years you should take, but maybe you just have been procrastinating just a little bit.
Yep. And it might be morbid to think about your death or mortality or all those things. But really, the point of having a estate plan is to save your relatives, too, a lot of grief and when you do pass along. So there's a lot of different reasons why you want an estate plan. So let's talk about some misconceptions, though. We have an Ask Dave question from Benjamin in Wyoming. He says, I don't have much of an estate, so do I need an estate plan? And this is one of those big misconceptions about estate planning in general.
Well, Benjamin, an estate is defined as the sum total of all your assets. So, Benjamin, do you have a car? If you do, guess what? You have an estate. Okay. So, people think estate planning is for the affluent, right? And I think the reason this misnomer came in is because of what was called federal estate taxes, right? Death taxes. But right now, according to current law, you only owe federal death taxes, estate taxes, not state, estate taxes, the kind that get triggered when you die, right? Wealthy people do estate plans, right? You only trigger those estate taxes if your net worth is over $12 million. That means if you're married, that means your net worth jointly has to be over $24 million. And most people are under those thresholds. But does it mean, just because you don't have to worry about estate taxes, does it mean you shouldn't have an estate plan? Absolutely not. Because the state in which you live is in which state does Benjamin live in? I forget.
Wyoming.
Wyoming. Okay. Again, I'm getting older here. You got to forgive me. Wyoming. So Wyoming has an estate plan for you. It's called dying intestate. They have rules. Every state has different rules that say if you die, this is how your assets are going to get distributed. And you need to know the intestate rules in your state. And I'm sorry, Benjamin, I do not know Wyoming's. But the chances of your distribution goals being exactly as what the state's plan is are slim and none, right? And that's why you need to have an estate plan, because you need to decide. You can't make these decisions from the grave. You got to decide before you're gone what you want, how you want things distributed, and not let the state of Wyoming do that for you. And by the way, stay tuned, rest of the show. We're going to talk about lots of other reasons why, even if you're living, it benefits you greatly for having an estate plan, Benjamin.
Benjamin, thank you so much for sending in your Ask Dave question. And if any of our listeners out there have a retirement question or a question about a topic you may hear on the show, all you have to do is send us an email at askdave@retirementincomesource.com, and you may hear your question answered on a future show. Thank you for listening to the Retirement Income Source, where it is all about the income. I'm Sarah Samuels here with Dave Scranton. Today we're talking about estate planning and really why a lot of people put off estate planning and some of these other misconceptions about estate planning, right? We just answered a question from Benjamin in Wyoming who was saying, hey, I don't have an estate. I don't have assets. Do I really need a plan? And of course you do, because as Dave said, if you don't plan for it, your specific state will have a plan, and most likely you're not going to like that plan, because how are they going to get it right for you, right?
Those are called intestacy laws.
Intestacy.
Dying intestate means dying without a will.
Yeah.
You know,
the Latin, right? Yeah,
and you think if you have a lot of people think, another misnomer, a lot of people think, if you have a will, my assets avoid probate. Well, that's not true at all. In fact, the reason you have probate is to prove the validity of a will, right? Because imagine, Sarah, you're gone, and I show up with a will that says you're leaving everything to me, right? And your heirs are looking at you going, well, wait a minute. Justin's saying, well, what? Wait a minute.
How'd that happen?
Yeah. Well, what happened to me, right? Well, I showed up with his will.
Yeah.
So the court has to prove that this is the valid last will and testament. So probate is really designed to protect the decedent, protect the person who's gone, right? Yeah. But you go through probate whether you utilize the state's intestacy rules or you have your own will, your own set of guidelines. But the biggest reasons for doing estate planning, and again, I want to get to the living stuff, but even from a death standpoint, Sarah, is to stop infighting with your family, right? If you have children, think about what happens. Kids fight over things, and sometimes it's financial assets, but a lot of times it's not. Sometimes it's about, dad's gun collection, or maybe it's mom's jewelry collection, right? It's something like that that has sentimental value that they want to fight over. So how do you stop that infighting? You stop it by putting your wishes in writing before you die, so that everyone knows this is what you want. And it helps to let people know too. Let people know, look, this is what you're going to get. This is what you're going to get. Let's make this clear. These are my wishes, right? And the same is true if you don't have children, right? Just siblings. Same thing with siblings. Sometimes one sibling is disappointed, thinking, well, I thought I was going to get X. Why am I not getting it, right?
Yeah.
And that's what these types of things do.
Yep.
And Sarah, you can go online and you can get a will for free, and you could really cheap, and you could do it yourself. But, I want to talk a little bit later in the show about why I don't recommend that, and why, have an attorney really do it to make sure you're doing it the right way probably makes sense. So coming up, we're going to talk about why spending a few bucks with an attorney to do the will the right way probably makes sense, but also discuss some of the living reasons why you don't have to die to get benefits from having an estate plan. All that and more coming up. I'm David Scranton here with Sarah Samuels, and this is the Retirement Income Source, where it's all about the income.
Welcome back to the Retirement Income Source, where it's all about the income. I'm Sarah Samuels here with Dave Scranton, and today we're talking about estate planning. And right now we've really been talking about the reasons why most people tend to put off creating an estate plan, and why that can be so dangerous. Because by creating an estate plan, you are going to prevent future infighting, right? We know that if you have kids, especially multiple children, there might be fighting, might be issues in between them when it comes to who's the executor or who has what in the will. So when you have a will laid out there, it's very important. It's an important piece of estate planning.
And not just infighting, but disappointment.
Disappointment,
Sarah.
right.
Right. One person's disappointed, and maybe it affects the relationship with a sibling, and things that you never want to have happen. Especially, you never want to these things are going to happen. You don't want to be the one who causes it, right?
Right, and you'll be gone, unfortunately, so you won't be able to respond to it too. So that's why it's really important to plan for an estate. I'm sorry, that's why it's important to create an estate plan. But should you do this yourself, Dave? Is this something that it's easy to do, or is this really something where you should hire an attorney?
Well, I've read, I've watched YouTube videos on, things like appendicitis and things like that, and it looks pretty easy getting in there and removing an appendix.
You think you could do it? Do that surgery?
I had science class, and we
Yeah.
dissected animals in class. I could probably do it, but I'm not going to, right? It's not something you're going to do. And here's the problem. When you start talking about wills and trusts and death and dying and everything, at the end of the day, if you mess it up, it's not like any other contract. Any other contract, you can go to court and say, well, that's not what I meant. That's not what I meant. I meant this, and we explained this when we developed this contract, right? Because by definition, when you have a will, by time that will goes to the court for probate, you're dead.
Exactly.
If you've made a mistake, you can't explain yourself. So it's great that you can save money by doing it on your own. But, I've got to tell you, there are plenty of attorneys out there in most areas, maybe not some big cities, but in more rural areas where, well under $1,000, you can get a will and some other basic documents. And to me, it's a small investment to make sure that it's done the right way and that you've got somebody there as an advocate that knows what your wishes truly are. So, there's some things you can cheap out on if you want, but cheaping out on a will, in my opinion, isn't one of them.
Yep. And that's one of those things that you don't want to cheap out on, again, because you don't want to potentially cause more issues down the line. Once you're already gone, if you go online maybe and you just Google, hey, what's a free will that I can download? Or maybe you spend $20, you download a template and put it together yourself. It's a little bit different than maybe doing your taxes for yourself, right?
Yeah, I agree.
Yep. All right. So let's talk about the other options. We know about wills, but what about a living will, for example? So we have a question from George in North Dakota. He says, what's the difference between a will and a living will? And is a living will a good option?
Well, George, a living will is a great option. It's something you should have because, again, you want to avoid any infighting, right? So with a living will, what you're doing is you're stating your end-of-life intentions, okay? Do you want to be kept on life support? And you could define what the life support means. Do you want to be kept on artificial nutrition? Yes or no? Because that's an emotional thing. Just like after you're gone, George, your kids or your heirs might, be disappointed arguing over certain personal items or even financial items. But in the real world, the same arguments happen when you're in a coma and you can't make medical decisions for yourself. Now, one child says, hey, Dad would have wanted the plug pulled, and the other child says, no, we want to keep him here as long as possible. So putting your wishes in writing clarifies it. And now there's no guilt. If they pull the plug, it's because Dad said so, okay? Now, if Dad doesn't want that and you want to be kept on life support as long as possible because you think they might find a magical cure, hey, then that's your choice too. But again, it's just letting your intentions be known. And George, while you're looking at a living will, you're also going to get a designation of healthcare agent, okay? What that is a document that states who is going to be your healthcare agent that's going to make these decisions for you. So the doctor will rely on the healthcare agent whom you designate, and the living will is instructions to that healthcare agent to let that person know what your intentions are, what you really want at end of life. And again, this makes it easy because now there's no fighting. You could have 3 kids or 10 kids, and you've said, this is the one child that I put in charge of this. Why? Maybe it's the most practical person that you know is going to follow your wishes versus your daughter that's going to be there crying by your bedside every day and not going to allow you to pull the plug, right? So again, durable power of attorney, living will, 2 great documents that go hand in hand.
And George, thank you so much for sending in your email with your question for Dave. If anyone has a question that you would like Dave to answer, maybe it's about retirement or maybe it's about the topic of the show, all you have to do is email us at askdave@retirementincomesource.com. And thank you for listening to the Retirement Income Source, where it is all about the income. I'm Sarah Samuels here with Dave Scranton, and we're talking about all of the different things that go into estate planning, plus some of the psychological reasons why people maybe want to put off estate planning, why everyone really needs an estate plan too. Even if you maybe don't have a very large estate, you still need to plan for it. And we've talked about just recently, Dave, the living wills, the difference, right, between a will and a living will, and why a living will is so important, especially if you're incapacitated in some way. And to me, Dave, it almost seems like everyone who, once you're a legal adult, almost you should have a living will so that people can know what your wishes would be, because anyone can become incapacitated and in a coma at any time.
It's part of what I call the 4-pack, right? So for you listeners, hopefully, if you're not driving, you can jot this down. If you are driving, then please don't jot it down, right? But the 4-pack is having a will to determine where your assets are going to go when you're gone, having a living will to give your end-of-life instructions, how much life support you want and don't want, under what circumstances, having a designation of healthcare agent, which designates somebody to help make those decisions, so the doctor has your permission to listen to that person within the parameters of the living will. But the last part is the durable power of attorney, because it's great to make healthcare decisions, but now who's going to make financial decisions for you if you're in a coma, if you're incapacitated, right? So you have to name that person, because if you don't, then every time bills have to get paid from your account, then somebody has to go to the court and request permission from the court, and they have to name someone who's going to be able to pay the bills, and they've got to approve those bills, right? So now you're eating up court fees and legal fees like crazy. Simple durable power of attorney covers that problem, because with that durable power of attorney, you're saying, I name so-and-so to pay my bills and to manage my financial affairs if I'm gone. And by the way, Sarah, guess what? If you and Justin get married, it doesn't make a difference. Why? I know you're going to get married, but when you get married, guess what? It doesn't make a difference. Because the spouse doesn't even have that ability without a durable power of attorney.
Wow. So even if you're legally married, that the spouse still needs to be your stated durable power of attorney.
That's right.
That's interesting.
You need to put it in writing.
Yeah.
So again, the 4-pack, right? A will, a living will, designation of healthcare agent, and a durable power of attorney to make financial decisions in case you're incapacitated.
Yeah, because you really need someone, Dave, to worry about, not just, if you're incapacitated, right? You need someone to make health decisions for you, but you also need someone to make those financial decisions, because just like if you die without a will and you're stuck in probate, you don't really want the state making those decisions for you or having to appoint someone. It's a lot more grief and a lot more trouble for everyone involved in your family and your heirs.
Most states can't even run their own business of running the state, let alone running my financial affairs. It's the last thing I want. That's right. And then there's just catches, too, you have to realize, like the living will we talked about, right? You should renew that living will once a year. Because believe it or not, there are some situations I've heard. You've heard about you might remember, you were younger, but you might remember hearing about Terry Schiavo, right?
Oh, that was actually in Florida. So I remember that. It was a huge case in Florida.
On life support for years and years and years. They didn't have this. In some cases, you might go there with a living will from Justin and say, hey, this is what Justin wants. He says, pull the plug. Don't keep me on life support, right? And the doctor looks at you and says, I'm sorry, that was 4 years ago. I can't accept this. I don't know. Maybe Justin's goals have changed over the last 4 years. It's not recent enough. And they can choose not to accept it. So the safe thing to do is to re-up that every single year, rewrite it every year, to minimize the chance that some doctor, for CYA purposes, disregards what's written on the living will.
Yeah. Now, when it comes to estate planning, we can't forget about trust. So can you benefit from utilizing a trust, or who would really benefit the most? We're going to talk about that coming up. I'm Sarah Samuels here with Dave Scranton, and you're listening to the Retirement Income Source, where it's all about the income. Welcome back to the Retirement Income Source, where it's all about the income. I'm Sarah Samuels here with Dave Scranton. Today we've been talking about estate planning and all of the different parts that go into estate planning, plus why a lot of people seem to really kick the can down the road and what can happen, the consequences if you don't have an estate plan. And Dave, we also talked briefly about why you should hire an attorney when it comes to something as complicated as this estate planning process, and why it's not a good do-it-yourselfer option.
Mm-hmm. Yeah, and perhaps one of the biggest reasons, as we mentioned at the end of the last segment, is if you want to trust. That's part of it, because we talked about the 4-pack, right?
Mm-hmm.
Well, the trust makes it essentially a 5-pack, right? And a lot of people think trust like trust fund, like rich people, right? But there are lots of reasons why people consider trust funds. A trust is essentially a way to run your money from the grave, right? In a will, typically, as long as somebody is of adult age, the money gets dispersed after probate, and they can do whatever they want with it. Which is why, by the way, there's a scary statistic, Sarah, that most estates are squandered. The average estate is squandered in 90 days.
3 months, 90 days.
Squandered. People go out and buy cars, whatever, it's gone.
Did they say the size of the estate?
Well, I'm sure that's the smaller size,
Yeah.
but the point is, estates do get squandered because those who earn the money are better at keeping it than oftentimes those who inherit it, right? So, but with a will, everything goes outright. With a trust, it allows you to manage the money from the grave, right? Because you can say, okay, now I only want the money to be spent for this purpose or that purpose, or so much money can be distributed at age 30, age 35, age 40, whatever. You literally can make up your own terms. So that's one major reason for having a trust.
Yeah.
Another major reason is to avoid probate, right? A lot of people want to avoid probate because they don't want to go through the probate process. And there's reasons for that, which we'll talk about. But again, a trust is really just an alternative to a will. It's a different way of doing things that allows you more flexibility, more control, and more probate avoidance. So I find that even though people tend to think, well, that you hear trust fund kid, that's for wealthy people, it's really not. Like we said at the beginning, people think estate planning is for the wealthy, and people even more so think trusts are for the wealthy. But again, not necessarily the case.
Yep. Well, there are different types of trust, and our next Ask Dave question has to do with just that. So we actually have Jim from Alabama. He says, Dave, my kids are stable, they have jobs, and they're doing well. So do I really need a trust?
Yeah, Jim. Well, that's a great question, because the first thing that I do when I'm talking to people about whether they need a will or trust is, okay, do you have anyone in your family who you think's their kid's marriage may not be that strong? Or anyone who is a spendthrift that you think will blow the money? Or anyone who's got drug or alcohol issues, right? Because those are reasons why you might want to control it from the grave. But if your kids are in good shape with all that stuff, you might say, well, maybe not. Okay, I don't need that. But there are other reasons where you might need a trust. For example, let's say that, we mentioned before that the federal estate taxes kick in when your net worth's at $12 million. But depending on your state, and I don't know your state's particular rules, state estate taxes can kick in at $1 million, $2 million, $3 million, right? So you may want to buy some life insurance to pay those taxes. But if you buy life insurance and you own it, that makes your estate bigger, which makes the tax problem bigger. So you might want to set up an irrevocable life insurance trust, irrevocable, right? Because now that life insurance death benefit is out of your estate. It can cover the taxes, but it doesn't make the problem worse. Or if you have a child that has special needs. Now, in your case, Jim, it sounds like that's not the case. But if you have a child who has special needs who's going to be getting some state benefits, then you want to have a special needs trust. Because a special needs trust is a way where they can still get some use of that money that they might inherit, but without messing up their ability to get government benefits that they're absolutely entitled to as a disabled individual. Next, if you have property in a state other than your residence, right, then your heirs would have to do probate, not just in your state, but also in the state in which you have property, right? It's called ancillary probate. So you want to set up a trust for that piece of real estate to avoid probate, to avoid the second probate, okay? So again, there's lots of reasons why you might want to use a trust. even if your kids are all buttoned up, good kids, successful, and got their heads screwed on straight. But the other biggest reason, which we'll talk about more coming right up, is if you want to avoid probate and why you might just want to avoid probate, Jim.
Well, Jim, thank you so much for sending in your question for Dave to answer. And if any of our other listeners or our YouTube viewers out there have a retirement question, or maybe you just need some financial advice, all you have to do is email us at askdave@retirementincomesource. That's SOURCE.com. And thank you for spending your weekend here with us, listening to the Retirement Income Source, where it is all about the income. And today's episode is focused mostly on estate planning and the reasons why people maybe they don't want to estate plan, why they kick that estate planning down the can, right? They kick that can down the road. They don't want to do it right now. Plus, why you should really hire an attorney. And the biggest thing we've talked about right now in this block is the trust, the difference with the trust, and why you might want to have a trust, even if your kids are doing well, maybe even if you don't have a special needs child. But the other big reason to have a trust is you want to avoid probate. So Dave, can you explain why you want to avoid probate, or why you may want to do that?
So like I said, in its basic nature, probate's a good thing because it proves the validity of a will, proves, okay, which will is correct. So some scam artist can't come up with a phony will and take all your money when you're gone, right? That's a good thing. But there are probate fees, there are court fees, and the probate fees vary from state to state. Some states are more benign, some states are worse. Also, probate delays the receipt of the money. So, for example, you could take, several months, a year, with a simple probate before the money gets released to the heirs, the beneficiaries. Now, we've all heard about some big estates, right? Some of the movie stars you've heard about, the Elvises and the Michael Jacksons, whose estate goes on forever and ever, go in probate. So it could actually take years in some cases before that money gets released to the proper heirs or beneficiaries. But the third reason is that it's public information. See, when you probate, the whole point is the court says, so-and-so died, and these are his or her assets. Do you have a claim on any of those? So that nosy neighbor you have, right? I know you have them, Sarah. We all do, right?
Of course.
You can go down the court and say, oh, what does she have? What does she have? What, this and that. So a lot of people decide, you know what? I want to avoid the probate fees. I want to avoid the delay with my heirs getting it. I want to delay. I want to keep my nosy neighbors from seeing it. I want it to be private, not public. And also, I just want to make it easier for my kids. I want to make it easier for my spouse, right? It's bad enough my heirs are going to be distraught when I'm gone. I don't need to complicate that in any way, shape, or form, by having the will. So in a lot of cases, a living trust is really a better answer, maybe in most cases.
Yeah. And you mentioned in your answer to Jim and our Ask Dave question, you talked a little bit about irrevocable trusts, but what's the biggest difference between the different trust types? Is that you can't make any changes versus the other one is kind of more of a living, breathing?
Well, it's a great question. An irrevocable trust is just that. It's irrevocable. When you put an asset into the irrevocable trust, it's there. It's there. So that's why the life insurance would go in a trust. Now you don't technically own it, so therefore you can't change beneficiaries or anything. An irrevocable trust is important for special needs because then, if the disabled child or person could get in there and grab the money, well, then the state's not going to give them their benefits, right? Or if you want to protect your assets against Medicaid, right? Most states have a 5-year look back, but if you say, hey, what if I go into a convalescent home? I want to protect this money for my kids. Well, if you feel comfortable doing it, you don't need the money, you put your money in irrevocable trust, and as long as you don't go into a facility for 5 years, now you can go on Medicaid benefits with the state, go into a convalescent home, and the money is preserved for your kids in the trust. Now, that's a slippery slope, Sarah, because most people, don't really know. Am I really going to need the money? Am I that sure? So an irrevocable trust is just that, it's irrevocable. Whereas a revocable trust, if you just want to avoid probate, a living trust is a revocable trust. So you can put your assets in the trust, you could take them out. And that's why most people do a living trust to avoid probate. You don't give up any flexibility at all, you don't give up any control. Everything stays just like it was, except that now you avoid probate. So revocable means you can revoke it, you can take the assets back out, you can make any decision you want. Irrevocable means it's in there for good.
Yep. Well, trusts are one way that you can avoid probate, Dave, like you mentioned. But we're going to talk about some other ways that you can actually avoid the probate process if that's something that you would like to do in your estate planning. I'm Sarah Samuels here with Dave Scranton, and you're listening to the Retirement Income Source, where it's all about the income.
And welcome back to the Retirement Income Source, where it's all about the income. I'm David Scranton here with Sarah Samuels, and today we're talking about estate planning. So although that may not be directly all about the income, but indirectly it is. So far we've covered wills and why it's important not to die without a will, because guess what? The state in which you live has a will for you, and it's very inflexible. But we also covered the living benefits of having some of this 4-pack, as I like to call it, right? A durable power of attorney, naming somebody who can make financial decisions for you if you're incapacitated. A designation of healthcare agent, someone who can make healthcare decisions for you if you're incapacitated. And a living will, giving that healthcare agent instructions as to what you do and do not want for care at the end of life cycle. And Sarah, sometimes those are different people. You might have one person who's really good with numbers. Maybe your daughter is the accountant. She's really good with numbers. You want her being the executor of the will or having the durable power of attorney. But maybe because she's your little girl, she's never going to pull the plug. So maybe now you want to have your son, who's the engineer, right? Who's very black and white. Say, okay, let him have my designation of healthcare agent. So sometimes you name different people to do different duties.
Yeah, but overall that helps avoid any of the infighting that can happen later on when you've passed. If you've actually named these people, everyone has a specific role to play. Mm-hmm. It's a little bit more organized, and part of it too is that with trust in particularly, we talked about that's actually one way that you can avoid probate. But there are other ways to avoid probate, right, Dave, if that's your goal?
And the reason it's important is because anybody could take against a will. It's harder to take against a trust or a beneficiary designation. But you could take against a will, and that really slows down the probate process. So what else can you do to avoid probate? Well, the first thing is to understand that certain assets by nature avoid probate. Pension plans, 401ks, 403bs, deferred comp plans, right? These are all beneficiary-driven instruments. They avoid probate by nature. Life insurance, you name a beneficiary, it avoids probate. IRAs, you name a beneficiary, it avoids probate. Annuities, name a beneficiary, it avoids probate. And Sarah, here's the thing: probate, the probate, who you put as a beneficiary, supersedes the will. So there's a famous case, the Kennedy case, where this guy changed the will to have his second wife inherit everything, right? But when he died, he had an old account that had a beneficiary on it, and he forgot to change the beneficiary. The beneficiary was his ex-wife. So they took it to court, and the court ruled in the Kennedy case, landmark case, that the beneficiary designation supersedes the will. So everybody agreed on the intentions. The intention was for everything to go to the new wife. But guess what? Because the beneficiary of the old 401k was to his ex-wife got that money, and there was nothing anybody could do about it. Okay? So important to check the beneficiaries at the same time you're doing your estate plan and make sure they're the people you actually want as your beneficiaries.
Absolutely. Well, our next Ask Dave question actually has to do with this, Dave. So we have Lisa in Colorado. She says, all of my assets are in IRAs or TOD accounts. So do I really need a living trust to avoid probate?
All right. So, Lisa, for quick clarification for our other listeners, they sound pretty astute with this. You mentioned TOD. TOD accounts are transfer on death. In some states, they're called payable on death. But it's where you have a non-beneficiary driven account, a bank account, a brokerage account. And you put somebody's name on as beneficiary, right? Now, it doesn't have to be one of those other accounts I mentioned. A TOD account applies, okay? Just like a joint account with right of survivorship, right? Most people, Sarah, if they're married, have a lot of joint assets. The real estate's joint title with right of survivorship. That passes to the other owner outside of probate also. Okay? But to get your answer, whose question was this now? I forgot. I'm sorry.
Oh, this is for Lisa.
Lisa. Okay. Mm-hmm. Sorry, Lisa. these math guys, right? We know numbers, we forget names. Sorry, Lisa. But Lisa, in your case, if everything is beneficiary driven, IRA, 401k, life insurance, or TOD, transfer on death for those taxable accounts, or jointly titled with right of survivorship with your spouse, then you don't need a trust if one of you dies. Okay? But if you both die in a common accident, now there's a problem, because that is where oftentimes you die in a common accident and everything goes to your children, and they're not named as backup on these documents, all right? So if one of you dies, the other one survives, then you can get the trust. But you're taking a chance, because if you both go together in a common accident, then you could have issues. So yes, Lisa, there might still be benefits for you to look into a living trust, even though you seem to be pretty buttoned up and knowledgeable on other ways to avoid probate.
And thank you, Lisa, for sending in your question. And if any of our listeners out there have a question that you would like Dave to answer, maybe even on a future episode of the show, all you have to do is send us an email at askdave@Retirement Income Source. That's SOURCE.com. And thank you for spending time with us here on the Retirement Income Source, where it's all about the income. I'm Sarah Samuels here with Dave Scranton, and we've been talking about estate planning, all of the different parts that go into an estate planning, plus some common misconceptions when it comes to estate planning and what can happen if you end up dying and you don't have a will in place. You haven't set anything up, how your state that you live in actually has a will for you, but you're probably not going to like it. So Dave, just to recap, what are the most important parts of an estate planning? Let's go over your 4-pack or even your 5-pack again.
So yeah, the 4-pack turns into a 5-pack with the trust, but the basic 4-pack is a will, durable power of attorney if you become incapacitated, somebody makes financial decisions for you, designation of healthcare agent, same thing, but designate somebody different to make healthcare decisions for you, and a living will to give that person instructions as to what types of end-of-life care you want and don't want. The trust is the 5th, and really is the tool that either lets you run the money from the grave or lets you avoid probate in the case of a living trust. But Sarah, I think the bottom line, though, is this, and I hate, when we talked about doing the show, I hemmed and hawed. I didn't want to do the show because I think it's kind of morbid in some ways, but I really want to motivate people to take action, because it is one of the places that people just put off over and over again, or they think they have it done, they haven't updated it in a while, and then they do it for crazy reasons. Like I heard somebody's recently said, well, I'm traveling to Italy, so I want to get a will before we go to Italy, right? Well, the chance of you dying in a car accident in your own town are greater than in an airplane flying to Italy, right? But people, those things motivate people. So hopefully today, if you're not trying to go to Italy, hopefully Sarah and I have been able to motivate you just a little bit. And, here are the things. Sarah, I think it's important for everybody to realize that it's not permanent. A will can be changed. You can create a will, and it might cost you, again, under $1,000 for the 4-pack. And yet, if you want to change it, it might only be a couple $100 for a minor change. So if you can't agree on who the guardian is for children, name somebody. Whoever you pick is going to be better than the courts, right? Name somebody who's going to be your executor or your trustee, right? Whomever you pick is going to be better than the person the courts would pick. Whoever's going to run your finances in case you're incapacitated. Same thing here. That gets costly while you're living, right? We promised you it'd be about living too. So imagine now you get in a car accident, you're in a coma for a couple weeks, and now every time, or maybe a couple months, but now every time something has to get paid, you got to get approval from the court. The court appoints a trustee. It's probably some attorney who's going to charge money. You can avoid that by picking somebody. You have to pick the best person, no. But pick somebody, because here's the thing, don't let perfection get in the way of progress. If you don't have these documents, or you have these documents and they're way outdated, right? Sometimes, Sarah, I see people whose executors are no longer living, whose
That's a
trustees
problem.
are no longer, right.
Yeah.
So don't let perfection get in the way of progress. Pick the best person you could think of, and if 6 months, a year later, you think of somebody better, then make that change.
And don't procrastinate. Don't think, I don't need it. It's not going to happen to me. Or, I'm going to Italy next year. Maybe I'll worry about it next year. That's hilarious, Dave, because you're right. Statistically speaking, as a numbers guy, you're way more likely to die in a car accident on your way driving to work than traveling abroad somewhere. But it's one of those things, I think it could sneak up on you. But if you prepare, you are going to help your family avoid a ton of grief down the road. You're also going to help avoid a lot of bureaucracy if you plan for this correctly.
That's right. That's right.
Nobody
Absolutely.
likes bureaucracy, right?
Absolutely. No. It's one of the few things you could do to make life easy for your kids. I see a lot of people a lot of times say, I want to protect my assets for my kids. I want to take care of them and so on. And that's all great. But the biggest thing you could protect them from is the grief that they go through, when that negative event occurs.
Absolutely. And if you like this episode, if you thought the estate planning information was interesting and maybe you want to share it with your family and friends, all you have to do is go to retirementincomesourceradioshow.com, and all of our past episodes are right there.